everybody. Keith here. Hoping everybody's having a good day, enjoying life, living life, loving life. Want to remind everybody, hit the like, share, and subscribe button. There is a PayPal link down there for anybody that wants to share some love. Every little bit is appreciated. Be sure to use friends and family. And, of course, the StreamYard link is down there for anybody that wants to join the panel. Open discussion tonight about Aaron Spencer. Is he a murderer or father of the year? And this is in relations to your free speech in the First Amendment and a certain situation that went on in this particular case. And Aaron Spencer, I don't know if you remember, but here a few days ago, I did the last tits out and balls to the wall, reviewing insane shorts and stuff. And it was one of the later videos, last shorts that we saw about Aaron Spencer and this man that had molested his daughter, had been arrested and then released with very little to no supervision or anything like that, minimal restraining orders, some shit like that. And then after he was released, he was caught again with this man's daughter months later. And this time the father caught up to him and shot and killed him with his daughter in the man's possession. He was literally in the act of kidnapping, whether it was to molest her again or to take out a witness, I don't know. But come to find out, the gentleman that did this, the man that did this, the beast that did this, was a prior county sheriff. So before we get into the video I want to review, I've got a thing I pulled up as relations to the case to give you guys a case background on it. And basically what we're looking at here is the public court records in Arkansas Supreme Court. And we're talking about the Arkansas Supreme Court because, like I said, they handed down a gag order in the situation. On October 8th, 2024, deputies were called to a household in Lonoke County after a report of a missing teenage daughter. Aaron Spencer, the father, located her in a vehicle with 67-year-old Michael Fossler, who had previously faced criminal charges for sexual assault, stalking of a minor, and possession of child pornography related to that same daughter. Fossler had been released on bond in July, violating a protective order. So in other words, in July, he was processed for a certain number of cases. I think they said they ended up charging him with 47 cases in July on this one incident. And they then turned around and let him out. And in that, they gave a protective order, which he violated in going and getting the child again on October 8th. Okay. Spencer reported that Fossler attempted to prevent his daughter from exiting the vehicle. This is after Aaron Spencer caught up to him in his truck. He spotted him in his truck, knew his truck, and he saw him and his daughter in the truck. And he says Fossler attempted to prevent his daughter from exiting the vehicle and lunged at him. Spencer then shot Fossler multiple times with a Glock 19 Gen 4, and he emptied the magazine, pistol whipped Fossler, rescued his daughter, returned to his truck, reloaded, and called 911 again, because he had already called 911 when he woke up and found that his daughter was missing and started looking for her. That's when he spotted the truck. Fossler died at the scene. Spencer called 911 initially when the daughter was missing and again after the shooting. Notice how they use the language here, rescued his daughter. Okay, this is from the public record. I imagine this is probably from a description from one of the news outlets. Okay. It doesn't say, well, yeah, it says Arkansas Times right here. Rescued, Arkansas Times described it as rescued his daughter. That's a matter of public opinion, according to the Arkansas Times. Okay. Understand this part right here. Okay. Public opinion, according to Arkansas Times, as they put it out, to help the public opinion believe that he rescued his daughter. Okay. That's the language they used. On November 27th, 2024, prosecutors formally charged Spencer with second-degree murder and a firearm enhancement with it. So, murder with a firearm. Okay. Spencer pleaded not guilty and was released on a $150,000 bond the following day. On December 4th, 2024, the prosecution requested a gag order due to widespread media coverage. The trial court granted it and sealed the case. Requested a gag order due to widespread media coverage. The trial court granted it and sealed the case. Spencer challenged the order, citing due process and First Amendment rights. Okay, and they give a just-ya-law here. Thing I want to point out here is widespread media coverage comes from his attorney that made one statement, and we'll hear that later in the video. That was the widespread media coverage, was the one statement in alignment with Arkansas Times saying that he rescued his daughter and that the general public would agree with this sentiment. That was the basic context of the statement made. And so they're trying to say they have to put a gag order on it because they don't want it to be a court of public opinion. A court of public opinion. In other words, they don't want the public to be able to speak out about it through their First Amendment freedom of speech, as well as if that gag order is put on, it violates that First Amendment in your right to know. Your right to know the devious actions that these people are partaking in. On May 29th, 2025, the Arkansas Supreme Court vacated the gag order and sealed filings entirely. The High Court sharply criticized the lower court's broad restraints on speech. First Amendment, like I said, both my freedom of expression and your right to know. Just like in the defendant's situation where they put the gag order and included him, that's a violation of his freedom of speech in order to bring out the relevant facts that they're trying to hide, as well as his right to know the facts that they are hiding that haven't gotten out yet. Remember, we talked about the other video here recently with the young gentleman. What was his name? Oh gosh, I can't remember. I'm having a brain fart. Usually, I'm good at remembering this stuff. But the gentleman we just did a video on yesterday, Mr. Pipsqueak. Mr. Pipsqueak. The firings, resignings, and retirings happen up the line. And I imagine, since this isn't over yet, that's one of the processes we're going to start seeing. And yeah, pattern of practice, folks. Okay, including by public officials and the sealing of records without evidentiary justification. Pretrial hearing is scheduled for August 8th, 2025. That's next week here. Okay, and then a 5-day jury trial is set to begin September 22nd. 2025. Okay. So let's take a look at just-ya as it relates to Arkansas Code. Arkansas Code of 1987 and its amended 2024. Use of deadly physical force in defense of a person. Section 5-2-607. Use of a deadly physical force in defense of a person. Justification. A person is justified in using deadly physical force upon another person if the person reasonably believes that the other person is, one, and we don't need to go any further, committing or about to commit a felony involving physical force or violence. The taking, the kidnapping has already occurred. He is in the commission of it, and the father is the one that caught up with him first. And he has the right to use deadly physical force just as well as the police. Any questions on that? Greetings, everybody. Funny stuff, Barney. Funny stuff. Barney says, gag order from a cross-dresser has no standing. Don't like it? I do. That's funny. So let's get into it. This here is dad finds police chief with daughter on trial for murder. And this is a video from Lackluster. Lackluster. Go over and check him out. Does a lot of great videos.
How many pages per minute do you think you read?
Page a minute, probably.
This company is going viral for its new process that gives you permanent
Damn
teeth
commercials.
in just 24 hours.
If the defendant in this case filed a 19-page objection, and 6 minutes after that was uploaded to the system, 6 minutes, the circuit court filed the answer with multiple handwritten interlineations, do you think that we can fairly assume that in those 6 minutes that she read, considered, and gave due weight to the defendant's objection in this case?
Welcome.
So want to hear that again? Because I think that's one of the most important aspects of this video as to their competency and as to whether they're actually doing their job when they say, I'm just doing my job. No, they're deleting records, hiding things, running these gag schemes and contempt schemes and administrative schemes. And everybody believes that it applies to them. When personal jurisdiction, in order for the court to obtain personal jurisdiction, the plaintiff must serve the defendant in the state in which the court sits. This must be a due process of service through a third party. That third party can't be the officer on the side of the road as a complainant saying he saw you speeding, using a dangling participle verb at that. Okay, so understand what's going on here. And nobody's competent of their job because they're not doing their job. They're Hitler's willing executioners pulling in idiots, useful idiots, to run a marketing investment scheme. It's as simple as it gets. Court registry investment system, taking private people into an administrative venue and using the data elements in a converted form for an investment system through the judiciary. Amazing shit. So let's listen to it again.
So let me ask you, how quickly do you read?
As quickly as I can, Your
So
Honor.
how many pages per minute do you think you read?
Page a minute, probably.
If the defendant in this case filed a 19-page objection.
So a page a minute at 19 pages, that's 19 minutes. Yet here we have someone that professes to be able to read all 19 pages and consider the elements in there, doodle all their notes, and give it good consideration and weight of balance as it goes to the operation of law, jurisprudence, good faith and fair dealings, full disclosure, all those kind of things, integrity. Public service is a public trust. They have an oath of office. They're duty bound. And yet they sit there saying, I'm just doing my job when they're not doing their job. Pay attention.
And 6 minutes after that was uploaded to the system, 6 minutes, the circuit court filed the answer with multiple handwritten interlineations. Do you think that we can fairly assume that in those 6 minutes that she read, considered, and gave due weight to the defendant's objection in this case?
Welcome back to the Lackluster channel. In spring of 2024, a man named Michael Fosler targeted and groomed a 13-year-old in Lonoke County, Arkansas. The girl was being homeschooled at the time and was caring for a terminally ill relative. A 67-year-old man began texting her, and by July of 2024, the girl had disclosed to one of her family members that she was assaulted. The girl's father, Aaron Spencer, is a combat veteran, and upon hearing of these allegations, he and his wife Heather reported the abuse to the authorities. Soon after, Michael Fosler is arrested, and he's charged with 43 felony counts, including internet stalking of a child, 4th-degree SA, indecency with a child, and possession and distribution of CP. As it turns out, Michael Fosler was an ex-police chief in Indiana and had ties to several law enforcement authorities in Arkansas, and not long after his arrest and arraignment, he was released on an extremely low bond. No electronic monitoring.
Okay, so he wasn't the sheriff right there, but it says he was a police chief in Indiana, and since he'd moved to the Arkansas area where he was at, he evidently being a police officer, got in with the local police department as one of the good old boys. You know, you can trust me. I'm a police from over here. You know, so we're seeing that the blue line extends beyond the actual holding of office and stuff, and just to like a brotherhood. You know, the blue line. It's a brotherhood. It's a fucking gang.
Was imposed, and only a no contact order was issued.
And just so y'all know, if you don't like my opinions, you can suck it, because that's all they are. Just my opinions.
During this time, the girl is put into therapy, continues homeschooling, and the family continues to care for her. Just a few months later, on October 8th of 2024, at about 1 o'clock in the morning, the Spencers hear a dog barking. It's their dog. So Aaron goes to investigate, and what he finds is that instead of in his daughter's bed, his daughter's sleeping, there's a stuffed animal hidden under a hoodie. Heather Spencer immediately calls 911 as Aaron leaves the house, jumping into his truck to search for his daughter. The entire family is now looking for the child, as no one knows where she's gone. And what they find is a Cash App transaction from Fosler to the daughter that says DoorDash, as Aaron Spencer is driving through his neighborhood looking for his daughter. He spots Michael Fosler's white F-150 driving through his streets as he passes the
I don't know why it keeps doing this. I do have it set on fast, so let's slow it down a little bit, see if that helps.
truck. He can see Michael Fosler driving and his daughter in the passenger seat. Aaron Spencer immediately calls 911 to report locating them and begins following the vehicle. Aaron follows Michael's vehicle down Highway 236 East for quite some time, flashing his headlights and honking his horn, but the truck won't pull over. And when there's no response from the driver, at intersection 236 and Highway 13, Aaron rams Michael's truck into a ditch. Aaron exits his vehicle and draws a Glock 19, ordering Michael to get out of the car. According to reports from Aaron, Michael was preventing his daughter from exiting the vehicle, and after arguing with the man, Michael eventually exited his truck with an unknown object in his hand, rushing Aaron, which is when Aaron shoots Michael multiple times. He then retrieves his daughter, returns to his truck, reloads his pistol, and calls 911 again. Aaron is arrested and booked into the Lonoke County Jail, but is released the next day on a $150,000 bond. After the shooting, the Lonoke County Sheriff put out this statement.
I'm your Lonoke County Sheriff, John Staley. In the early hours of Tuesday, October 8th, Lonoke County deputies responded to a report of a missing juvenile. While en route, got a call of a shooting. After consultation with the prosecuting attorney, an arrest was made with a preliminary charge of first-degree murder. Arkansas state law provides guidance on when and how charges are filed in criminal cases. As this is an ongoing investigation, only limited details can be released. As your sheriff, it is our duty to conduct a thorough and factual investigation. Law enforcement does not file charges. We gather evidence and submit a case to the prosecutor, who will then decide whether or not to file charges. Currently, official charges have not been filed. I have not.
So less than 2 months later, charges were filed. So in 2 months, they did a proper investigation. Came up with all the details, but they don't want to put them out. They want to put a gag order on it. And they don't want to put all the details out.
Nor will I advocate for any specific charge. This is a tragic situation, and my thoughts and prayers are with all those involved. We will continue our investigation, submit the findings to the prosecutor for review.
But it isn't until November 27th of 2024 nearly a month and a half later, that prosecutors charged Aaron with second-degree murder and commission of a felony with a firearm. About a week.
So the prosecutor doesn't just go out and pick up the charges. If the police, if that man didn't want to follow up on charges, why did he follow up on charges? Huh?
And how charges are filed in criminal cases. As this is an ongoing investigation, only limited details can be released. As your sheriff, it is our duty to conduct a thorough and factual investigation. Law enforcement does not file charges. We gather evidence and submit a case to the prosecutor.
We gather evidence and submit a case to the prosecutor,
who will then decide whether or not to file charges. Currently, official charges have not been filed. I have not, nor will I, advocate for any specific charge.
So before the investigation went on or was fully conducted, he's saying that he will not advocate for any specific charges. So how did the investigation come up with charges under his detail? He is the sheriff, Sheriff J. Staley. How did the charges come up under his detail if he didn't advocate for him?
This is a tragic situation, and my thoughts and prayers are with all those involved. We will continue our investigation, submit the findings to the prosecutor for review.
But it isn't until November 27th of 2024, nearly a month and a half later, that prosecutors charged Aaron with second-degree murder and commission of a felony with a firearm. About a week later, on December 2nd, Spencer pleaded not guilty to the second-degree murder charge. That same day, Judge Barbara Elmore limited all pretrial publicity, and just 2 days later, the state filed a motion for a gag order, citing extensive media coverage of the case. It should be noted that Barbara Elmore was also the judge who was ruling over the Michael Fossler case, and was the one to release him on bond. His charges were dismissed as a result of being deceased, and now she will rule over Aaron Spencer. The circuit court granted the gag order without even holding a hearing. This would effectively seal all the records in the case and limit any interaction between the family and the press. Fast forward to early February of 2025. Aaron Spencer filed a petition for writ of certiorari with the Arkansas Supreme Court, seeking to vacate the gag order, arguing that it vacated his First Amendment rights as well as his constitutional rights to a fair and public trial. In early March, the Arkansas Supreme Court agreed to hear arguments about the case, specifically about the gag order, and put a stay on the circuit court case. A stay is basically hitting the pause button, ensuring that the case does not move forward. This is important because the case was supposed to be heard by a jury on March 19th of 2025.
We are here today on a gag order imposed at the inception of a criminal case in the circuit court. Gag orders should be a last resort, not a first impulse in any case. And I would submit to you that's fairly settled law. The criminal justice system does not favor justice in the dark. And that is what is happening in Lonoke County. Aaron Spencer is a father and a husband. His daughter was assaulted severely by a man named Michael Fossler. Michael Fossler was arrested and charged with over 40 criminal offenses relating to his behavior against Mr. Spencer's child. He was released by the Circuit Court of Lonoke County with very little restriction.
So, counsel, if I can interrupt you right there, just a factual clarification. Was it the same judge who issued the gag order was the judge in that case?
Yes, sir. And thank you for that question. You caught exactly where I was going. It was the same circuit court and the same prosecutor who participated in Michael Fossler's criminal proceeding. And that's important in additional respects. There is no public record of his appearance that I can find before the circuit court. There's no record of what bond the state sought, why the court imposed such a low bond, why there were no restrictions or supervision as to his conduct. And of course, that led to him taking Aaron Spencer's daughter in the middle of the night to continue to rape her.
Counsel, I have a question. We live stream our court proceedings, and this is a public hearing. So, and it's live streamed. It's also saved on our website. Is that violating the current gag order?
That is an excellent question, and also on my list of things to discuss before this court. This gag order is so overbroad that I don't know that I can answer that question.
And that's what we're getting at here is the broad scope of this this gag order that this judge put out. And you're going to find out here later on that this court has already heard the exact same thing and already vacated it. And they're bringing it up in a certiorari here because they refuse to hear the motion to dismiss, the 19-page motion to dismiss that you heard about with the 6-minute gap, showing that they just blatantly didn't even pay attention to it. It's just, they're just trying to railroad this guy.
Precisely. My belief is that this court has asked for this argument, and I cannot fulfill my duty to this court without explaining the facts and the law that apply to it. But the way the gag order is written, none of you could speak about the case from the bench here. The governor herself couldn't speak about the case if she wanted to. No public official could speak about the case.
Counsel, in preparation for the argument,
And as you notice, this is live stream stuff, right? She even mentioned, we stream these sessions live. Does that mean we are not allowed to discuss this in this venue right here? It's a very pertinent question and shows the broad scope of that insane gag order. It's set up to violate everyone's First Amendment right in both scopes of freedom of speech and everyone else's right to know.
all the court has 2 law clerks on staff, 2 attorneys. Were we in violation of the order when we were discussing it with our law clerks in preparation over the last few weeks?
Arguably, you could be, because arguably you're discussing it for purposes of public dissemination. I mean, presumably you intended to come here and ask questions about it, and you intend to publish an opinion that pertains to it. So I suppose arguably you could be. That seems outrageous.
So even if you assume that that's all true, I mean, I guess I'm confused. What's your standing to raise those arguments as to non-parties? I mean, I understand that Mr. Spencer can raise the argument as to him. He can raise it presumptively as to counsel. But as to anybody else covered by this order, what standing do you have?
Yes, sir. There are several things that sort of fall into that category. But as a general matter, the overbreadth doctrine allows courts to consider First Amendment restraints that affect third parties. So I think that's discussed in the Murphy-Brown case, which cites a couple of Supreme Court cases for that point.
Third parties like public news agencies and such.
But for overbreadth to apply as a general matter, you have to first allege that this can be constitutionally applied to you. The reason why we conduct the overbreadth analysis is because it's constitutional as applied to you, but it's unconstitutional theoretically as applied to others. Here, your argument is it's not constitutional as applied to you. So I'm a little bit confused how we get to overbreadth.
Well, either way, I think it's unconstitutional as applied to my client, in part because it's overbroad and it encompasses both his right to speak and his right to receive speech. The First Amendment covers the communication itself on both ends, which is why all the cases.
Exactly what I was talking about.
Speak and his right to receive speech. The First Amendment, it encompasses both his right to speak and his right to receive speech. It encompasses both his right to speak and his right to receive speech. The First Amendment covers the communication itself on both ends, which is why all the cases.
Are there cases that treat overbreadth that way? I mean, I'm not familiar with any.
No, that's a bit of a different doctrine. So think of all of the cases most of the cases that are out there involve the press, right? The press is coming forward and saying, we oppose this gag order that you have imposed that prevents all the parties from speaking. And the press is the recipient of that speech. And most often the defendant doesn't want the speech, but the press is still allowed to bring that motion. At times the parties bring the motion, but they are addressing whether they can speak and whether speech can be provided, for instance, in public records.
And I guess my question is, if we found the gag order is unconstitutional to you, your client, is that sufficient, or are you seeking more relief? And that's why you've argued over it. Because normally if we said it was unconstitutional to apply to you, the analysis would stop. There's a stack of First Amendment cases that say that the analysis stops. Would you be satisfied with that relief, or are you seeking to invalidate the entire gag order? And again, what's the standing for that?
I don't think that the court has to go that far, because I think that it's unconstitutional as to Aaron Spencer, and that would cover all of the concerns, because there's really not a part of this order that is sufficient.
Right. And so that 19-page motion to dismiss the gag order would be, I presume, based on that constitutional right. And therefore, that is the one issue that needs to be made. And that is the one issue they're ignoring. That one issue is probably all the different points that he made in his 19 pages. And they don't want to listen to any of it, because that means they would have to redraw their gag order and specifically limit it to those sections that they can. Because otherwise, like she's explaining, his right to speech and his right to receive speech. Right to speak and the right to know. My right to speak it and your right to know. And obviously, your right to speak back to me so I know. This is the equal consideration, equal benefit in a contract. It's the same thing, just different language.
Sufficiently clear, that indicates a substantial compelling interest that's narrowly tailored. So I think that if the court decides that the order itself does not comply with constitutional mandates, then that is sufficient to get to the end, which is that it needs to be submitted back to the circuit court for a proper analysis.
So a slightly different variation of this question than what I took some of your arguments to be framed as. Yes, they were sometimes.
And the proper analysis would be based on his motion to dismiss for this, this, and this. That way they can correct this, this, and this, and still have a gag order for that, that, and that.
Time framed in terms of overbreath. I thought maybe you were making a facial challenge as to the gag order itself and just arguing it's unconstitutional in all of its applications. Am I wrong about that? Or?
That's a tough question for me to answer. I believe that it is facially unconstitutional, but I don't think the court has to reach that point. I think for purposes.
And I agree there, because again, if the court doesn't reach that point, it would be a matter of addressing that motion to dismiss for such, such, and such. And like I said, redrawing the gag order so it does fit. Otherwise, you're going to hear these guys up here saying, well, like I said, they vacated already, point for point already, in its entirety, not just in part. They already vacated in its entirety.
Of our argument, pointing out the circuit court's disregard for the rights of the people that it encompassed in the order, and for the overbroad.
But that sounds like a facial challenge, right? That when you start talking about other people, if it's an overbreath challenge and we decide that it's unconstitutional as to you, the analysis stops. So you've either got to say it's a facial challenge or it's not really an overbreath challenge at that point. So which is it if you're talking about other people?
Well, the point that I'm trying to make is I think that is important evidence of the order's overbreadth and the problem with the circuit court's lack of analysis. I think that
Counsel, what I thought I heard you say earlier was that it wasn't just that you're arguing that prohibiting the defendant's speech, it was his receiving speech as well. And is that why it in a sense, you're arguing it's unconstitutional, the restrictions on others is because it prevents them from him receiving their speech?
Your Honor, thank you, Justice Wood. My point there was just that the First Amendment protections are both as to recipient and speaker. In this instance, our position is that Aaron Spencer, the attorneys, the people that represent him, his family, any interested party should both be able to speak and have access to the information necessary to speak. So, for instance, closing all court records. And by the way, there were no court records made public. So even the
Yes, because it affects more than just Aaron. As you know, it affects his attorney or attorneys. He probably got multiples. It affects his wife, his child, his family, his employment, for crying out loud, his entire life, their entire lives. So it's a broader scope of who it applies to than just Aaron himself.
affidavit of arrest or the charging document.
And I think that's why they vacated it in its entirety.
Are public. But he has a right to access those records and share them with other people. That is speech.
That seems to be slicing it. I mean, putting too much emphasis on one point. I mean, courts seal records all the time for various reasons. Now, maybe you don't think there's sufficient justification here. There, as far as I can tell, there really are no fact findings here. So maybe it's not warranted here, but there's not some abstract right. I mean, I don't think you can identify a case, can you, where the courts have recognized an abstract right to access information that says courts can't seal the records.
I'm sorry, Your Honor. I believe that the right to a public trial includes the right of public access to court records.
Does it include the right to release evidence? To obtain in discovery then, in your view?
No, I think discovery is treated differently. Discovery is regulated under court rules. I'm, as an attorney, prevented from disseminating discovery material. There's no need for a gag order in that respect. The court rules cover that. So I think the case law also suggests that discovery, the United States Supreme Court has addressed that discovery is a separate and protected class. I'm dealing only with the public record aspect, and I agree with you that absolutely the court can seal records after the appropriate analysis has been undertaken that shows a need to do so. In this instance, we have sealed every public record. In fact, I noticed that since we filed the final brief in this case, the circuit court clerk has added some notations to the electronic docket online. But while we were doing briefing, you couldn't even see the title of documents that were filed. There's no record of my client's entry of a not guilty plea. The public was prevented.
Read correctly at some point that the arraignment was actually sealed?
The arraignment, the court would not allow community members in the arraignment. I raised an objection. It was not well taken. And so they were not allowed in the courtroom.
So no members of the public, no members of the press allowed at the arraignment?
I can't swear to that because my back was to them, but I watched the bailiff and heard him tell numerous members of the public that the court had ordered that only 2 members of the defendant's family and I believe 2 members of the victim's family would be permitted in. Whether or not he ultimately let somebody slide in, I cannot attest to that, but he turned away a line of people. And it wasn't 100 people, it was about 8 or 10, and he turned them all away.
So we haven't even, are you raising a right to public trial? Because we haven't, extended that beyond we haven't extended that to arraignment and further.
No, Your Honor, I'm not. But it is an important consideration here because Aaron Spencer may not have taken so much issue with this gag order if it didn't seem like this entire proceeding and the entire proceeding of Michael Fossler were being conducted in secret. And the public, members of Lonoke County, have a great interest in knowing how this happened and knowing why its public officials are making the decisions that they are.
Ms. Casanelli, you said something a minute ago that made me think that the remedy you're seeking here is for this court to remand or send this back to Lonoke County Circuit Court to have a hearing. Is that what you're asking for?
I'm asking this court to vacate the gag order and provide the court and all courts in Arkansas with some kind of analysis, some kind of careful balancing, some direction. And
The proper consideration and evaluation of the balancing of that motion to dismiss. It's fine to have a gag order to prevent that third party, the news, from spreading the information of the case into the public so that they can't have a proper jury pool. Okay? And when it becomes a matter of public opinion like that, in a situation like this, and they're going to speak about it, it becomes a matter of jury nullification if the people are bright enough to understand what that is.
for the circuit court and all circuit courts to conduct such analysis before they impose a gag order, to ensure that it is appropriately narrowly tailored, only as is necessary to prevent substantial prejudice. That's what I'm asking for. And in this instance, the circuit court undertook no analysis, took no evidence. So there is nothing on which a tailored gag order could be created and imposed.
So the standard you just articulated, which case does that come from? I mean, I know that the cases say various things at various times. It's a little bit unclear what the U.S. Supreme Court has told us the standard is here. Where are you getting your standard from? What is the closest match? And is it the same standard applied to everybody that this gag order applies to, or is it just the standard that applies to you and your client?
So I would submit to you that the standard doesn't matter. Under any of the standards that have been laid forth by the Supreme Court, this gag order fails. I could talk all day long about whether Gentile sets a standard or Nebraska Press should be used, but I don't think my evaluation is that there is not a rigid test. I think the Supreme Court has said repeatedly, like the clear and present danger is not a formula. It is an indication of the careful balancing that should be done to ensure that a gag order is addressed only to a substantial and compelling public
The
interest.
balancing language, where does that come from? I'm not familiar with the case that says balance.
Nearly every U.S. Supreme Court case talks about the weighing or the balancing.
But does it actually apply a balancing test as one would traditionally think of it, or does it just say we balance the?
And so you would think that this exact same gag order has gone to this same Supreme Court once before and already been vacated in whole, that, as she mentioned, that she would prefer a balancing test. You would think that that would have been the preference back then as well, and that they would have already had a balancing test, because as we hear here, that is one of the questions about this very subject. And I'm wondering why it didn't come up before. It didn't seem like there was a proper balancing test. Again, to the competency of people that are investigating themselves and saying that they're doing the job for the people. Well, how many times does it have to go before a Supreme Court to finally get something proper done about it? Instead of handing it back to the same incompetent people that are obviously trying to railroad somebody. Here, redo this to your own favor. Just make sure you don't violate this guy's rights anymore. How do you think this man's going to get a fair trial if the jury of his peers is selected from everybody that has a fucking state ID, already indoctrinated to believe that that judge is going to hand down the rules of the court and that they have to do what the judge says?
In formulating the standard, we balance the interest, or is it a pure balancing test?
It is not a pure balancing test. The court has been clear that it's unique to every case, but that it has to have the hallmarks of applying the heavy presumption of unconstitutionality as to a prior restraint, such as a gag order.
And in response to Justice Hudson's question, you were asked, what are you seeking here? Are you just seeking sending it back for hearing? And you said you'd like guidance, but what I just heard from you is an amorphous test that doesn't really provide that. I mean,
unfortunately, the United States Supreme Court hasn't addressed this situation because most often it's a defendant's assertion of a right to a fair trial that was not honored because of change of venue, or it's a press case. So I think we're looking to this court to help us in the state, to help us combine those cases and come up with what is the proper direction. But I do not mean to insinuate or indicate at all that there is a rigid balancing, because I think that the constitutional rights at issue don't allow for that.
do I take from your answer then that you think the standard varies depending on whether the state has asked for it versus you've asked for it?
No, I do not think the standard varies. I think that the circumstances of the case are necessarily going to make, for instance, the state's compelling interest in a fair trial is going to have a different weight under the circumstances of each different case, as will the need to narrowly tailor the order. It necessarily has to be.
I mean, in this case, the weight of the interest of the state is that of public indoctrination, because they don't want a jury of his peers that would do the exact same thing. They want a jury that they can convince that no man in his right mind would have done something like that. They want a bunch of bitch-ass slaves indoctrinated to carry that state ID and pay tribute to that false patriarch instead of what's doing right and true.
Specific to the case, but we could use some real guidance as to what courts have to do to evaluate those issues.
Your time has expired. You can continue and do your rebuttal, or
Thank you.
thank you.
Thank you. Madam Chief Justice, and may it please the court, I'm Assistant Attorney General Joseph Carlucci here today on behalf of the respondent, the state of Arkansas. The Circuit Court's gag order in this case was an appropriate exercise of its discretion that helps achieve its primary constitutional duty to ensure
State's gag order was inappropriate. What did he say? Let's listen to that again.
today on behalf of the respondent, the state of Arkansas. The Circuit Court's gag order in this case was an appropriate exercise of its discretion that helps achieve its primary constitutional duty to ensure a fair trial occurs in this case and that justice is done. Reviewing the Circuit Court's gag order in this case was an appropriate exercise of its discretion that helps achieve its primary constitutional duty to ensure a fair trial occurs in this case and that justice is done. That helps achieve its primary constitutional duty to ensure a fair trial occurs. The Circuit Court's gag order in this case was an appropriate exercise of its discretion that helps achieve its primary constitutional duty to ensure a fair trial occurs in this case and that justice is done.
Yet the exact same gag order was brought to the Supreme Court prior, 2020 or something like that, and they already vacated it. I think you failed, buddy. I think you failed.
The Circuit Court's gag order in this case was an appropriate exercise of its discretion that helps achieve its primary constitutional duty to ensure a fair trial occurs in this case and that justice is done.
To ensure that a fair trial is had in this case and that justice is done, using a template document that's already been used and vacated. See, that's what happened in that 6 minutes. They have a lot of faith built on that template document that was already used and vacated before, that they think they can get by with it again. So long as they keep getting away with using the same shit, righteous people are going to go down to, and do life for doing a righteous thing, saving children in the hands of beasts in the moment, when they have every absolute right of nature to do so. This is the insanity, people. And this is why it's so important to understand Hosea 4:6. My people are destroyed for lack of knowledge. If you don't know this stuff, they're going to keep running that same game on you.
Reviewing this order and Spencer's claims under the intermediate scrutiny standards set out in Gentile versus State Bar of Nevada.
Counselor, what would be the harm in sending this back to Circuit Court for an evidentiary hearing?
I think the harm is that there is sufficient evidence in the record to support the order here. It is undisputed. They didn't dispute it below. They haven't disputed it here, that there was sufficient media attention, expansive media attention, that supports the idea that there is a substantial likelihood of material prejudice based on statements from trial participants. And then the other thing you have is the statement that was attached to the state's order, which represented
the statement. This is what I was talking about. This is what they're afraid of.
an effort on the part of the defendants and his attorneys to try this case in the press. And when you have a clear attempt to try the case in the court of public opinion rather than the courtroom, then it is appropriate to prevent.
Wasn't there just one statement here?
We feel very confident that this community is going to come to Aaron's side because every one of them would have done the same thing for their child or their neighbor's child or a member of their family.
I mean, you only attached, I think, one statement from defense counsel. I mean, that seems like a little bit of a jump to say there's been one statement.
Because every one of them would.
To prevent.
Wasn't there just one statement here?
We feel very confident that this community is going to come to Aaron's side because every one of them would have done the same thing for their child or their neighbor's child or a member of their family.
I mean, you only attached.
To prevent.
Wasn't there just one statement here?
We feel very confident that this community is going to come to Aaron's side because every one of them would have done the same thing for their child or their neighbor's child or a member of their family.
I mean, you only.
To prevent.
Wasn't there just one statement here?
We feel very confident that this community is going to come to Aaron's side because every one of them would have done the same thing for their child or their neighbor's child or a member of their family.
I mean, you only attached, I think, one statement from defense counsel. I mean, that seems like a little bit of a jump to say there's been one statement that the defendant says was in response to something that the prosecutor had said.
One statement, and let's issue a gag order that's so broad it covers everybody and everything in all situations.
Cryptically, like that seems like a bit of a jump, doesn't it?
There is only the one statement in the record. That's correct, Justice Browning. But I think when you read that statement, you can see the intent behind it. And the fact that it was in response, or may have been in response to statements made from the state, those statements aren't in the record. The fact
The intent behind it is that every reasonable and logical man, woman would do that for any child, theirs or their neighbors. And I think that's a true statement and not a matter of public opinion. I think that's a true statement as it goes to the nature of our being, the principles of the laws of our nature. I think that's the important concept to understand, no matter what religion you follow. Anyone caught stealing one of the children of the brethren of Israel and making merchandise of them shall be put to death. In the U.S. law, that is called kidnapping. The man was in the act of kidnapping the other man's daughter. No way around it. And so, as we see, they're going to keep pushing forward with pre-trial hearing on August 8th, and then the trial set for September 22nd. I hope the people out there that are selected for the jury are conscious enough to end the trial immediately with that jury nullification.
the state may or may not have made statements only further supports the need for the gag order. The fact that both sides are talking means that a gag order is appropriate. And when you read the substance of the statement, it contains a style of argument that wouldn't be allowed in court. It has evidence as to the character of the accused and the character of the victim that may or may not be admissible. And so this court, the circuit court, needed to ensure.
And here they're calling the victim the child predator that was murdered or killed. He wasn't murdered, he was killed.
Sure that the case is decided based on the evidence that comes from the witness stand, and that's what the gag order does.
But you jump from one point to the other. I guess where I'm confused is I'm not aware of a case that says you have a right to, the state or anybody else, a right to a trial without any publicity, which almost seems like what happened here. The circuit court decided there should not be any publicity. Instead, your right is to an impartial jury, right? And why wouldn't things like voir dire be sufficient for dealing with that? I didn't see any findings to that effect here.
One, I think because voir dire was raised in the defendant's briefing below, it's implicit that it was rejected by the circuit court. I think you can find an implicit finding there. And I think what the Shepard versus Maxwell case says, and what Gentile itself says, is that when we're looking at ensuring a fair trial, the court has to act prospectively to prevent prejudice before it happens.
Counsel, let me ask you something. I think you just said that it was included in the defendant's objection below. Are you talking about the 19-page objection that they filed to the request for the gag order?
Yeah, I think they mentioned.
So how quickly, and you said that because it was included, it's fair to assume that the circuit court considered that and rejected that. Is that a fair assessment of your argument on that point?
I think you can assume that.
Okay, so let me ask you, how quickly do you read?
As quickly as I can, Your
So
Honor.
if you had to guess, how many pages per minute do you think you read?
If I'm reading carefully, a page a minute, probably.
So if the defendant in this case filed a 19-page objection, and 6 minutes after that was uploaded to the system, after the clerk accepted it and uploaded it to the system, the circuit court, 6 minutes, the circuit court filed the answer with multiple handwritten interlineations in the order, excuse me. Do you think that we can fairly assume that in those 6 minutes, from the time the 19-page objection went live until the time the circuit court filed her order, that she read, considered, and gave due weight to the defendant's objection in this case?
As quickly as I can, Your
So
Honor.
if you had to guess, how many pages per minute do you think you read?
If I'm reading carefully, a page a minute, probably.
So if the defendant in this case filed a 19-page objection, and 6 minutes after that was uploaded to the system, after the clerk accepted it and uploaded it to the system, the circuit court, 6 minutes, the circuit court filed the answer with multiple handwritten interlineations in the order, excuse me. Do you think that we can fairly assume that in those 6 minutes, from the time the 19-page objection went live until the time the circuit court filed her order, that she read, considered, and gave due weight to the defendant's objection in this case?
First of all, I would reject the premise of the question. I don't think there's any evidence. They have alleged 6 minutes in their briefing, but all we have in the limited record before this court is the file stamps. And the file stamps of the order and the file stamp of the response indicate 2 separate days. That's all this court has to consider. And I don't know that we can know for sure whether or not the court had access to the response before it was pushed through by the clerk. I can't speak to that. I know the response was before the court and it had the opportunity to consider it. So I think we can find an implicit finding
Counsel,
here.
let me ask you another question. When you're talking about discretion, and I think that's what Justice Womack's getting to, you said the court exercised discretion. This order is substantially the same as an order that we vacated in 2020. So I guess how much discretion really was there? And it wasn't a carefully crafted order because it's obviously looks like a standard order that's being passed around either by prosecutors or by judges at the circuit court level. This order is substantially the same as an order that we vacated in 2020. So I guess how much discretion really was there? And it wasn't a carefully crafted order because it's obviously looks like a standard order that's being passed around either by prosecutors or by judges at the circuit court level.
I think
Substantially the same as an order that we vacated in 2020. So I guess how much discretion really was there? And it wasn't a carefully crafted order because it's obviously looks like a standard order that's being passed around either by prosecutors or by judges at the circuit court level.
I think you're dealing with who's making the petitioner here. The petition is the defendant, not the press, and we treat press.
And so the important point to understand here is that this hasn't just been presented to the Supreme Court twice, but evidently, like the judge on the bench said, it seems like it's a template that's being circulated through the district court or circuit courts. It's not just a one-time or two-time use. It's a template that's being used throughout the circuit courts. Pay attention to what's said and what's not there.
Cases differently than those of the defendant. And I think when you're looking at the order here and whether it's narrowly tailored, I would compare.
But we vacated it completely. We didn't just vacate it as to the press. We completely vacated it. And it had the same limits as to the defendant, the family, the friends, judicial officers. It was same language.
Looking at the order here and whether it's narrowly tailored, I would compare.
But we vacated it completely. We didn't just vacate it as to the press. We completely vacated it. And it had the same limits as to the defendant, the family, the friends, judicial officers. It was same language.
Looking at the order here and whether it's narrowly tailored, I would compare.
But we vacated it completely. We didn't just vacate it as to the press. We completely vacated it. And it had the same limits as to the defendant, the family, the friends, judicial officers. It was same.
Exact. The same. So what's your comparison? You would compare it to what? The template that was already used? Exact. The same.
Same language.
I'm not aware of that case, so I can't speak to that, and I apologize for that. But what I would ask this court to do is compare the restrictions here.
Yeah, because you look like a fool here. This man looks like a total fool. In my public opinion, this man looks like a fucking fool.
With the restrictions that were present in the rule in Gentile, and they are very similar. The rule in Gentile is found in the appendix to one of the opinions, and that was found to be narrowly tailored for First Amendment purposes. And so I think that this order
for purposes of the defendant's counsel, perhaps, but one, it wasn't prior restraint, right, in Gentile, so that's different. And that was a case about defendant's counsel. Here, I think you can see, correct, that this order goes beyond defendant's counsel and applies to the defendant. Why doesn't that make a difference? Where do you get from Gentile that standard applies to others?
I think two things in response to that, Your Honor. In terms of why it would apply to the defendant and other parties, Gentile, while it did specifically address lawyers, it said, some of its language said, because lawyers have.
This man is physically shaking here. This man is so nervous. He knows he already knows he's lost. And he's nervous as fuck up. It's a theatrics. Okay, this is all for show. Like Bad Barney No Bullet said, this is all just a show for the sheeple. That's why they live stream this stuff. But most people don't know how to interpret it and tear it down like I do and tell you the certain aspects as it relates to the law and its process.
Special access to information through discovery, client communications, extrajudicial statements. Their statements are likely to be received as authoritative. All the parties here that are restrained are in the same boat. A statement from the defendant is likely to be received as authoritative because he knows what happened. And so.
No, he knows what happened, and that makes his statement firsthand, not authoritative as if it came through an attorney or a judge or something like that. It's firsthand. And that's the problem. You cannot violate somebody's firsthand observances, ability to contemplate that observance, and then express that observance. as it happened firsthand. You cannot do that. That's the whole point of having a trial, is so that the man can get on the stand and testify.
So the same justification that applies to lawyers would apply to him. I would also say that while Gentile dealt with a subsequent punishment, the bar rule at issue there was a prior restraint on the attorney's speech. It was a rule that existed that restrained the entire attorney's speech, who was then subsequently punished. But I think it can be viewed as a prior
So
restraint.
that one, you could make the argument in Gentile that was people directly connected. There is language to that effect, but here we have an order that applies to any public official now holding office.
Yeah, and my first response to that, Your Honor, would be that those claims aren't in front of this court. The defendant doesn't have standing to raise them. And then secondly, while I say that public officials may be broad and probably could be reformed, the idea that some public officials, like the sheriff who investigated the case, court clerk, other people who might have knowledge and were specifically directed, I think would fall into the same category as attorneys, defendants.
So answer the question that was raised earlier by one of the other justices. We're public officials. We all have clerks and administrative assistants. This morning, I sat in my office and discussed this case with 3 people that work for me. And we talked about the evidence and we talked about the issues involved. Did I violate Judge Elmore's gag order?
No.
Why not?
Your
Because it
discussion,
says any public official now holding office.
because the restraints in the gag order are for public dissemination. Your discussion
For public dissemination while we're listening to it on a live stream. This isn't live, but it was live streamed. So now you yourself, in that sense, would be violating the gag order by even addressing it in this public venue, which is public dissemination before you and I, the public, of the public opinion. Amazing that this guy has such an astute character that he can pass that off. Are you people paying attention?
in your chamber are private. And in fact, they're exempted from FOIA, that you have a right to in crafting opinions.
Facebook post by the Lieutenant Governor. Covered, not covered by this gag order.
Arguably covered by this gag order, and I think the state would concede that that's probably inappropriate. She doesn't have any special knowledge.
You say inappropriate, do you mean unconstitutional?
I don't know that it's necessarily unconstitutional, but I don't think I don't think that claim is before this court.
So your boss is the Attorney General. Every legislative session, the Attorney General has a package of bills. Let's say he wants to go to the legislature and ask for a bill that addresses this very situation. He wants to add an affirmative defense to the statute in this type of scenario and has to give the reason why he wants to do that. So he lays out the facts of this case.
I mean, we're party litigants to this case. I'm responding.
Okay, so let's say it's the governor's package.
I think
Did the governor violate Judge Elmore's gag order in doing that?
I think the term public officials is probably, if the public officials claim were before this court, it's probably the general proposition of public officials is probably too broad and should be reformed.
So what about family? Whose family? Is that spouse and kids? Is that the fourth cousin you met once at a family reunion 30 years ago that's talking about it at the coffee shop?
And I think that is part of the problem with the general term family, and it's the limits of the English language that perhaps that was not something the state requested. That's something the circuit court did on its own. I do think it is appropriate to restrain certain family members for the reasons I said. Spencer can't filter his speech through his wife or his mother or people that they would see as authoritative. But I think it would be appropriate.
Then are you reading in the provision that talks about release, to Justice Womack's question, release any purported extrajudicial statement? Are you reading that as a limitation into the family language? Or I guess I'm a little confused with the position.
I'm sorry, could you repeat that?
So the first here is basically you can't launder the statement provision, any purported extrajudicial statement of the defendant. Are you reading that limitation into the family provision? Or
And what they're talking about here is the different grammar and stuff like that as it relates to family language and court language, and not being able to discuss it with your family members to figure it out yourself in your own ways of communicating. Again, that First Amendment violation of freedom of speech, freedom of expression, and everybody else's right to know. See, if you have your house set in order and you know that my people are destroyed for lack of knowledge, and therefore the true benefit is the knowledge, why would you let anybody suppress that?
I think the order says that the family is a restrained party and that is a restrained speech. So I think that would apply. I think that's a fair reading of the
So
order.
counsel, if defendant planned to call his daughter to testify, he couldn't publicly announce that, correct?
No, under the terms of the gag order, the identity of witnesses are protected.
But then why is that necessary if you can publicly say the arresting and investigating officers and agencies are public and they're going to be necessarily witnesses? So why can the defendant not release his witnesses, but obviously the state can publicly name some of their witnesses?
And I think that first, I think that the defendant's daughter could be a witness either for the state or for the defendant, same as the investigating officers could be witnesses for either. And I just think that the terms of the order says that you're allowed to identify the arresting officers, but you're not allowed to release witness lists, and that's to try to ensure a fair trial by preventing witness.
A fair trial for who?
A fair trial for the public and a fair trial for Mr. Spencer. It's a fair trial for all parties involved and for the people of this state.
Your primary interest then is in avoiding tainting the jury pool. That's the state's interest here, or is there another interest?
Yeah, well, I think it's in ensuring a fair trial, which involves tainting the jury pool and protecting the witnesses from harassment. I think there's twofold. I think if you read the restriction in the order about the identity of witnesses, that would go towards protecting witnesses.
So what about then the restrictions on making statements about a witness's testimony after the witness has already testified? What purpose does that possibly serve with respect to either the jury pool or intimidating witnesses?
I think it depends. Depends upon whether those statements are made in a pretrial hearing or in a trial. I could see and concede that when
My apologies. My apologies. Didn't realize I was muted there. But the premise here is that when you express that freedom of speech, you have the right to know, and it's imperative to understand that that knowledge is the key to everything. And when you get on the stand and you testify to your firsthand experience, you are the originator of that content. You are the one giving the world the firsthand view through that freedom of speech. And to place a gag order and say you can't speak beyond the court after you've given testimony is bullshit. The whole premise of this nation is founded in that First Amendment, freedom of association first. And then your freedom of speech and your freedom of expression, the freedom of the press shall not be infringed. Just like the Second Amendment shall not be infringed. Not by no gag order. That would be unconstitutional.
the jury has already been seated, that there wouldn't be reasons to restrict statements anymore to the press as long as the jury is sufficiently sequestered or sufficiently instructed not to
Counsel,
make press accounts.
it feels as if the discussions that you're having with my colleague are having well-reasoned discussions about where this perhaps could have been limited more, tailored more, and that would have been the benefit of having a hearing in front of the trial court, where the trial court could have had these discussions about what really the harms were out there, what you were trying to prevent, and that would have happened rather than sort of whether it happened in a day or 6 minutes, a quick form response.
I think the circuit court had all the information it needed in front of it to craft the order that it did, and I think that that order is.
I think the circuit court had everything it needed in front of them to craft the order it did. No, it used a template like they said. Stop fucking lying. You see how dense this dude is? Unwilling to admit that they're going to vacate because they've already run the same fucking exact document before the same goddamn court. Unwilling to admit it. Unwilling to admit defeat. Well, let's go see if we can have them recraft it again. No, you didn't recraft it to begin with. You used a damn template. Stop lying.
It's narrowly tailored. It specifically targets public dissemination of the evidence in this case, and just that. And that's
No, it doesn't. Like I said, it violates the First Amendment right of the defendant and his family and those pertinent to the case by not allowing them to discuss it as it really is and limiting what they can discuss. The court doesn't have authority to do that, particularly the administrative courts.
to prevent.
And the
ensure-
fatal flaw with that is that we vacated a virtually identical order in 2020.
And I think that Gentile would say that
What
this,
does it really matter, does it? If, I mean, that's US, we're saying an Arkansas case.
I think when we're applying the First Amendment, what the United States Supreme Court says matters.
Well, I would disagree when they've raised an Arkansas constitutional right here.
And I don't know that
We can give more protections, correct?
we can give more
Okay.
protections. Did not develop an Arkansas constitutional argument. I don't think, while they did cite it, they did not develop it. They
It's hard to
purely
do
relied-
without a hearing, isn't it?
I
develop
think they
that
could have
argument.
developed it in their briefing. They had a full briefing schedule. This court requested additional briefing.
I have a question for you. On the last page of the order, right above the judge's signature, it says the entire case is now sealed. What does that mean?
Here goes another good one. The entire case is sealed. What does that mean? See, these people think they can make simple statements that cover everything so broadly that everybody's just going to accept it. This is the idiocy that you're putting up with.
It means that the public docket and the docket entries are no longer public. That's what I took it to mean.
That's what you took it to mean? Do we know what that means? Does that mean that we're not going to let the public into the various hearings and portions of the trial that happen going forward? What, do we have any extrapolation somewhere else in another document from the judge to kind of expound on what she meant when she said the case is now sealed, the entire case is now sealed?
No, the only thing I'm aware of is the court.
Yeah, see, if the whole case is sealed and they can't let the public in, then I guess it's not a public trial, is it?
The order before this court. And I think when we talk about sealing, I took that to mean sealing of the record. The defendant has a right to a fair public trial, and I have no reason to believe that that's not going to happen. I'm out of time. I would ask this court to deny the petition for risk.
I have a lot of reason to believe that's not going to happen. I believe he's not going to receive a fair trial because it's going to be jury nullification. That's what I'd like to believe, and I'm going to believe in it strongly. Because even though I know a lot of people are fools, just like I've been a fool. A lot of bitch-ass slaves out there. I, too, was a bitch-ass slave. But I see people coming around, and I have great faith in them. So let's see what happens. Because like I said, this guy's very nervous up here. And I can only imagine that people rising up and standing like this and not letting this shit happen. And standing up for people like Aaron Spencer. Because he did what any man would do for his own child. I suggest now is the time to do it, folks. I'm not calling for a violence. I'm calling for the support and coming together in the knowledge of all this so we can tell these people we're no longer subject because we're no longer stupid to your games. It's an administrative court, folks.
Thank you.
Counselor, as it applies to the other party, the non-parties and the non-participants. So essentially the family members and let me make sure I get the precise language, any public official now holding office, as it applies to them. By having a gag order on them, is there any prejudicial impact on your client's rights to a fair trial or your client's constitutional rights otherwise? And if so, what is that prejudicial impact?
I would say there is a prejudicial impact. Each case that I believe in state court and in federal court that's evaluated gag orders in a similar way has addressed the scope of coverage as to third parties or groups of covered third parties. I should have made that more clear earlier, whether or not it was specific as to a very, very precise prejudicial effect on the defendant. However, to answer your question, I do believe there's a prejudicial effect. I think my client has a right for the public to be aware of what's going on in his case, for the public to be able to access records so that the public can make its own assessments of how it feels about its public officials and about how its criminal justice system is being operated. He is a member of the public. While he's also a criminal defendant, he is a citizen of Lono County, and so is his family, and so are his children. And so I think it does impact him and prejudice him, both as a citizen and as a criminal defendant. And I think, however, to answer your question, I do believe there's a prejudicial effect. I think my client has a right for the public to be aware of what's going on in his case, for the public to be able to access records so that the public can make its own assessments of how it feels about its public officials and about how its criminal justice system is being operated. He is a member of the public. While he's also a criminal defendant, he is a citizen of Lono County, and so is his family, and so are his children. And so I think However, to answer your question, I do believe there's a prejudicial effect. I think my client has a right for the public to be aware of what's going on in his case, for the public to be able to access records so that the public can make its own assessments of how it feels about its public officials and about how its criminal justice system is being operated. He is a member of the public. While he's also a criminal defendant, he is a citizen of Lonoke County, and so is his family, and so are his children. And so I think it does impact him and prejudice him, both.
What she said there is very important. Again, that's that First Amendment right. You have a right to know, folks. That's why I do this. I can explain it to you, but I can't comprehend it for you. But in that, I'm at least doing part of my duty to let you know what's going on with these public officials. They are not doing their job. They might say they're doing their job. But again, this seems to be a perfect example of Hitler's willing executioners. Willing to prosecute a man for doing what was righteous and that any other man would do.
As a citizen and as a criminal defendant. And I think every case that's analyzed this has, without real discussion, evaluated the scope as it applies to other people, as well as the scope of its application to different types of speech and other matters. So I think that that's a proper consideration. And it also, as I said before, contributes to the court's finding that the order is not narrowly tailored.
The state was saying is that they thought that perhaps some of what you said in the statement, you could not have said in court. Would you agree with that?
I'm sorry, I could not have said.
You could not have said in the court. You could have not made some of those statements.
Well, I have sort of agree and disagree.
Okay. Well, and so I guess following that is that once you did that, was there a legitimate concern by the court that maybe you were going to keep going further, and then that justified the court issuing some sort of gag order, if maybe not this far, against at least counsel?
I think the court, and I think the Trump court talks about this in that opinion, that context is important, and that has been completely ignored by the state in its briefing before this court.
The context is what matters. That's the subject matter. It has to stay within the context of the subject matter. So again, their gag order being so broad, covering every subject there is the issue. Again, you can't do that. That's blatant. And as it's been pointed out, this is the same judge that let the child predator go to begin with. In my strong opinion, this is straight up treason. You don't like it? I don't give a fuck. It's my opinion, and I'm allowed to state it. In my opinion, that woman should be hung. There's no reason to be moving forward with this case. The facts that are already out there are evident. Just the ones you saw in this video. And again, don't believe me, don't believe your neighbor, don't believe the government. And for crying out loud, don't believe your mother. Do your research so you know. That's what it's all about, knowledge. My people are destroyed for lack of it.
Statement was made before arraignment, before there was any proceeding. It is a criticism of a public official. It doesn't include any information that is prejudicial or would be inadmissible. The character of my client will be at issue because he is of outstanding character, and there's nothing that's going to impact that. Michael Fossler's rapes of Mr. Spencer's child are public record. It is a part of this case. And that statement is geared very specifically towards the prosecutor's decision to charge him after months of us cooperating and after knowing the circumstances that led us to that point. The very person who was responsible for Michael Fossler's case. So
was there a potential of suggesting jury nullification?
I do not believe so, because I think in a justification context that the jury has to assess what a reasonable person in Aaron Spencer's shoes would have done. There really wasn't a golden rule type argument, definitely not in the written statement. I want the court to know that the one comment that I made on camera at arraignment, which is also in a prosecution, in a justification context that the jury has to assess what a reasonable person in Aaron Spencer's shoes would have done. There was at that point, the very person who was responsible for Michael Fossler's case. So
was there a potential of suggesting jury nullification?
I do not believe so, because I think in a justification context that the jury has to assess what a reasonable person in Aaron Spencer's shoes would have done. There really wasn't a golden rule type argument, definitely not in the written statement. I want the court to know that the one comment that I made on camera at arraignment, which is also when a prosecutor made a comment on camera, what's recounted in the motion is a mash. I made brief statements, but they were related to the circuit courts having iced the community out of the proceeding.
A potential of suggesting jury nullification.
I do not believe so, because I think in a justification context that the jury has to assess what a reasonable person in Aaron Spencer's shoes would have done. There really
A potential of suggesting jury nullification.
I do not believe so, because I think in a justification context that the jury has to assess what a reasonable person in Aaron Spencer's shoes would have done.
A person is justified in using deadly force, deadly physical force upon another person if the person reasonably believes that the other person is committing or about to commit a felony involving physical force or violence. How stupid are these people? Let me read that again. It's in their own statutes, principles of criminal liability, justification, use of deadly physical force in defense of a person. A person is justified in using deadly physical force upon another person if the person reasonably believes that the other person is committing or about to commit a felony involving physical force or violence. The man had the child in his physical possession, running away with her in his truck. How stupid are these people? So again, understand this, even though she's the defense attorney, it's all theatrics even for her. A bright attorney would bring out the Arkansas statute and have it completely dropped. Because as she said, even the prosecuting attorney said it.
To charge him after months of us cooperating and after knowing the circumstances that led us to that point, the very person who was responsible for Michael Fossler's case. So
was there a potential of suggesting jury nullification?
Michael Fossler's rapes of Mr. Spencer's child are public record. It is a part of this case. And that statement is geared very specifically towards the prosecutor's decision to charge him after months of us cooperating and after knowing the circumstances that led us to that point, the very person who was responsible for Michael Fossler's case. So
was there a potential of suggesting jury nullification?
I do not believe so, because I think in a justification context that the jury has to assess what a reasonable person in Aaron Spencer's shoes would have done. There really wasn't a golden rule type argument, definitely not in the written statement. I want the court to know that the one comment that I made on camera at arraignment, which is also in a process.
There wasn't a golden rule. I call this one pretty fucking golden, if you don't mind me saying, because it seems to me that situations like this have already been ruled on and they've legislated it and put it in writing. Again, how stupid are these people?
Prosecutor made a comment on camera. What's recounted in the motion is a mash. I made brief statements, but they were related to the circuit courts having iced the community out of the proceeding. So if you don't take them in context, you may think that I'm talking about the jury as the community, but I'm actually, in full context, was talking about the community's involvement and support of him in that proceeding and being told to go home. So I think if the court had taken evidence, then we could have fleshed all of this out. My practice is not to try my cases in the press, and I would have probably agreed to some restrictions as necessary, depending on what they were, but the court didn't evaluate any of those things. And of course, the court didn't find out what I was speaking in response to. The public has a right to a fair trial, sure. They also have a right to hear my client's speech and to know what's going on in their judicial system. Thank you.
And so they weighed nothing on it. They didn't put any weight into anything. Because like I said, when it comes down to this stuff, they have certain duties that they're not doing. And the first and foremost duty is that of the prosecuting attorney. He has she has the obligation, responsibility, the duty to do what's called a pre-investigation to make sure that the charges are viable. And as a prosecuting attorney, again, I'll remind you of Arkansas statute, criminal offenses, general provisions, principles of criminal liability, justification, use of deadly physical force in defense of a person. Section 5-2-607 very plainly says in the very first sentence, a person is justified in using deadly physical force upon another person if the person reasonably believes that the other person is committing or about to commit a felony involving physical force or violence. In this particular situation, Mr. Fosler was in possession of a minor child, a female, for the second time after the first time having already been arrested on 43 charges involving child pornography, child sexual assault, and any man would reasonably believe that those kind of situations would happen again if that man came in possession of his child again. And those are felonies. And therefore, Aaron Spencer not only had a right, he had an obligation to take that man out. You don't like my rhetoric? Report me. See what happens. This is a free speech platform. It's my opinion. And again, I think that woman is committing treason and should be hung. How's that for a matter of public opinion? See, I'm telling you again, I see nothing but Hitler's willing executioners, people. When are you going to put a stop to it? Or are you just going to wait till they come to your door? What's going to be your plan of action? I want to thank everybody for joining me tonight. Please hit the like, share, and subscribe button. There is a PayPal link down there for anybody who wants to share some love. Roz, greetings. Thank you. Kindly appreciated. Did receive well. And you guys know me. I love you, but I don't give a rat's ass whether you love me back. That's to say, I don't care if you hate me. I don't care if you don't respect me. I don't care if you don't like my opinions. That's on you. So may God bless you and have a good day. We'll see everybody next time.